good afternoon, and welcome back to another edition of NCIA's Industry Essentials Educational Webinar Series, NCIA's premier digital educational platform designed to provide you all a variety of interactive programming to provide you timely, engaging, and essential education when and where you need it most. I'm Brian Gilbert, and as always, I'm very excited to welcome our dedicated network of members and supporters back to another special edition of our Service Solutions series, sponsored by International Institute for Conflict Prevention and Resolution. In today's program, members of the CPR dispute resolution team have convened a panel of leading cannabis arbitration, mediation, and litigation specialists to discuss the benefits of using alternative dispute resolution, or ADR, methods in cannabis contracts, thus bypassing the courts. As we all know, the cannabis industry continues to grow rapidly in both in the United States and abroad. However, cannabis companies face issues when entering into those contracts that they hope to enforce. Because the Federal Controlled Substance Act prohibits cannabis sales as a matter of federal law, many courts will not enforce a contract between cannabis companies, even if state law permits the legal sale of cannabis. Therefore, cannabis investors, businesses, and those who do business with them need a tool that makes their contracts enforceable. And luckily, that tool is why we're here today. So let's get this show on the road. Our panel will be leading an informative conversation so all audience members can take advantage of the benefits offered by using alternative dispute resolution methods in their business. So to kick things off, I'd like to welcome our moderator for today's program, Mia Levy, the Vice President of Global Development with CPR Dispute Resolution, to the virtual stage. You can activate your video feed and join us here. Fantastic. Welcome to NCIA's Industry Essentials. Great to have you here virtually today, Mia. I think before we kick things off today, you're going to quickly provide the audience with a little background on CPR dispute resolution before leading your guest panel through some brief introductions so our audience is aware of the background being brought to the table today. So with that, I'll turn it right over to you to get the conversation started.
Thanks so much, Brian. So just a little bit of background on CPR. CPR was established in 1977 as an independent nonprofit organization to promote prevention and resolution of conflict to better enable purpose. Through both the CPR Institute and CPR Dispute Resolution are two arms. The CPR Institute is our membership organization that drives and advocates for global prevention and resolution of disputes through thought leadership. And those members share best practices and develop innovative tools for dispute management. On the other side, we have CPR's dispute resolution team, which is a boutique provider of leading edge dispute management services, which covers mediation, arbitration, dispute prevention, and more, and is able to leverage those resources generated by the CPR Institute. We also maintain a panel of neutrals who are all experts in ADR and in their fields. And so CPR Dispute Resolution is really excited to be here today to present this program in association with the National Cannabis Industry Association. So thank you so much for having us. I'd like to introduce my co-panelist, Bob Koppel, who is an arbitrator, mediator, investigator, and litigation strategy consultant. He's arbitrated and mediated hundreds of cases, including disputes in a wide variety of sectors, but most importantly for today, he was on the ground floor applying alternative dispute resolution to the rapidly growing cannabis industry, and he's mediated and arbitrated many cannabis disputes. So I'm really excited to have him here today to share that expertise with us as well.
Thank you, Mia.
Great. So to get us started, we thought that we would just give a little bit of background on ADR for those of us attending who might not be familiar with what ADR is. So getting into that, ADR is essentially a private method of dispute resolution that keeps parties outside of the courts. So what does that mean? ADR really encompasses a wide variety of different mechanisms, but the most common and I think the most well-known are arbitration and mediation. And following these processes, parties are able to not take their case to court, to litigation, but instead solve them through so-called alternative means. But I do want to say that many industries are turning to ADR as more of a primary method of dispute resolution rather than alternative. So I don't know, Bob, if you have any other comments on that before we talk specifically about what arbitration and mediation are.
No, I think you're doing a good job. I think one thing though to remember is that ADR is a creature of contract. That is, and there are rare occasions where you have court-ordered ADR, but for the most part, it's by the agreement of the parties. And even if you subscribe to a particular set of rules, the parties still have the ability to modify those to meet their needs. I mean, I'd like to tell people that the parties could decide that they want to resolve their dispute by a game of rock, paper, scissors. Or the example I like to use is sabers at dawn, although that's probably unconscionable. But there's a great deal of flexibility. So when people ask, how do we do it? What rules do we follow? It's really up to you.
That's great, Bob. Thanks. And we are going to talk about all of the benefits of arbitration and mediation in general, and also as they apply to the cannabis industry. And I think that flexibility just mentioned is going to be one of the things that we primarily talk about. But so a little background on what arbitration and mediation specifically are. So mediation is a process by which parties can come together in front of a third party neutral. So a neutral who's not associated with either side of the case, who sits down and really helps them reach a mutually desirable solution. So maybe each side gets a little something of what they want, but might not get the extent of everything that they asked for. But it's a way to bring the parties together to find a solution that really meets both sides' needs. And so generally the way this is done is, the mediator brings the parties together to speak with the mediator individually sometimes, or speak with the mediator all together, and really talks the parties through the issues. Most disputes that do go to mediation can be resolved through just one mediation session. But if sometimes parties are unable to reach resolution, and in that instance, mediation is still successful because it has given the parties an opportunity to talk through their grievances and possibly narrow some of the issues, or at least resolve some parts of the dispute so that as they go forward to their next step, be it court, be it arbitration, or some other ADR process, they've already shortened the amount of time they'll need going forward and thereby reduced cost. Bob, do you have any other comments on mediation before we talk about what arbitration specifically is?
I will say a couple things about mediation to understand the process. First, you want a mediator who is familiar with your industry. You want a mediator who, in the course of negotiations, is going to be asking questions about your business, about your concerns, and then understand that one of the roles of the mediator is to test your nerve when it comes to your particular claim, to raise doubts, to ask questions that might cause the parties to reconsider their position and their willingness to settle. So it's a very dynamic process. I equate it to being a ringmaster in the circus for the mediator, that you're always keeping the plate spinning, you're keeping things going. And so understanding that part of the process, I think, helps.
Thanks so much. Okay, so arbitration. What is arbitration? Similarly, arbitration is also a private process outside of the courts. But in this instance, parties come before a third party neutral or three neutrals, a tribunal of three, who will decide the case for them. So rather than having the neutral help the parties reach a decision under arbitration, the neutrals are the ones who are the decision maker, much like a judge may be in court. However, And we'll talk about this as we talk about the benefits of arbitration. The neutral is selected by the parties or the panel of neutrals. And so parties really have say in whether the neutral has, a certain subject matter expertise, whether it's particularly in cannabis or some other technical aspect of the dispute. And parties can really decide who's going to be deciding their case. And we'll talk through the benefits, but just to bring up one of them, the process is generally final and binding. And what that means is once the arbitration is completed, the award is final. It can be enforced in court, but otherwise there's no additional process, there's no appeal. And so it really does cut down on the amount of time parties spend in this adversarial process and allows them to get back to their business, essentially. Mm-hmm. Bob, anything to add?
Just that, arbitration is basically a private trial, is what it is. But again, there's a great deal of flexibility. You don't have to follow, trial court type procedures. You can decide which issues are going to be addressed and which aren't. So that also contributes to both the economy and the efficiency of the process.
And, I think that's a really great segue into what the benefits of using ADR processes are. So to go into the first one, it's really this idea that the parties have control over the process. As Bob mentioned previously, they're getting to ADR. It's a creature of contract. So parties will write whether they want mediation or arbitration or other processes into their contract when they're drafting the contract at the beginning of the relationship between the parties. And so at that time, you can really craft the process to fit your needs, to fit any timelines. So you can set a procedure. When you select the rules you're following, there generally are default timelines and procedures, but parties can modify these. So if you really want to make sure that you're going to be utilizing an expedited proceeding because that there's something in particular between the relationship, or if it's, if you're thinking about product that has a shelf life and that you want it to be a quick process, you can utilize expedited rules. And so you can write those into your contract. For instance, CPR has a default of 90 days for our expedited rules, but parties can modify that as well. So it's really, the parties have control over the timeline, over the procedural aspects, and over the process in general. And I do, Bob, want to let you just jump in as you wish as we talk about these benefits.
Well, you're doing a great job, but I mean, I want to go to the extreme. For example, if you are in dispute with a partner, a vendor, an investor, you could say, we want to have a mediation next week, or we want to have an arbitration in 2 weeks, something that you could never do in a court where you may be sitting out there for 12 or 18 months before there's a final decision on your case. So it can move very, very quickly if you choose to do so.
Yeah, and that brings us to the next point, which is faster speed and lower cost. So, speed to a decision is so important when thinking about business, because you really want business planning to continue. You want any long-term projects you have or partnerships to be able to proceed uninterrupted. And as just mentioned, with court, you can have your case stuck in court for a very long time. And I think 15 to 18 months that you just mentioned was pretty generous when looking at the national average, which right now can go up to 2 years or more. And then the losing party has the right of appeal. So you can really be stuck in court for a very long time if it's a contentious case. Faster speed equates with lower cost. So not only are you, if the process is long, not only are you paying your attorneys, not only are you, possibly losing money, and spending a lot of time in the process, but the costs do continue to add up. And so the faster speed and the lower cost really go hand in hand. And it really just allows parties to just get back to the business at hand in a much more rapid fashion. Of course, parties, as mentioned, do control the process. So if getting back super quickly is not something that parties are interested in because they think there needs to be additional discovery or there are some issues that need to be investigated, it's something that can be built into the process. But even with all of that, overall, it's still going to be faster than going to court.
Absolutely, absolutely, and cheaper. And this is where I think lawyers need to pay particular attention, because trial lawyers like myself have a tendency to walk into arbitration and treat it like a trial to the court with discovery that involves turning over every stone. And as an arbitrator, I'm going to discourage that. I'm going to try to get you to be more efficient in terms of what information you really need and how quickly you need it so the process can go forward.
Right. So I think, these first 2 to 3 benefits, I think, are very widely applicable. But the following benefits I think we're going to really dive in on how they apply to cannabis disputes as well. So the next one is looking at who your decision makers are. So whether it's a mediation where you have a neutral who's facilitating the process, or an arbitration where you have neutrals who are going to be deciding your dispute and coming down with the award or the judgment, parties are able to select neutrals who understand the dispute. And this is helpful, I think, especially in cannabis industry disputes, because not only do you save time by not having to explain the subject matter. So, with a judge or a jury, you have to explain every technical aspect of the matter to make sure that they know it. With an educated neutral in the field, you might not have to do that. But also, the neutrals won't be biased against the cannabis industry, because you'll be able to select those neutrals who have experience in the area and understand it, and aren't, maybe a judge who would look unfavorably upon the dispute just at the outset because they don't like cannabis.
Oh, that's a very, very important point, Mia, because there's still a great deal of bias out there. I mean, you don't want Jeff Sessions as your judge. And we actually experienced that here in Maricopa County when we had a longtime county attorney who was a true believer and believed that cannabis, was the devil's tool. So by going instead through the route of ADR, you can pick somebody who has experience in the area, and with an assumption that there isn't going to be an anti-cannabis bias.
That's very true. And regarding, picking someone who understands the subject matter, this can really go throughout, whatever additional, like looking at the specifics of the dispute. So if it's a real estate dispute, for example, you can make sure that, you have a neutral who will understand the real estate industry as well. If it has to do with delay, you may want a neutral who, understands the repercussions of having, delay in delivery or delay in getting product to the shelves, or anything that might have to do, as you'd think about with cannabis or with food or beverage, whether there might be spoilage. So there are a lot of benefits in having a neutral who understands the specific subject matter, so that you don't need to have yourself, if you're counsel, or your counsel, if you're the party, spend time explaining those technical aspects, or explaining, why it's bad that whatever happened, which goes back to speed and cost again, because you really, not having to spend that time explaining those issues mean you can just get to the dispute and get to the decision in a faster manner.
Right. And also, I think that ADR is particularly applicable to the cannabis industry, because if we look at how it's developed from state to state, you see these partnerships that come together very quickly in order to meet application deadlines. And oftentimes the parties really don't know each other very well. They haven't worked together in the past. And so you see many partnership disputes within the cannabis industry. The advantage of ADR is that hopefully you can get that dispute resolved and the partners can get back to doing business.
And, I think that that last point is very applicable, because when you think about using processes such as mediation before getting to arbitration or court, it gives the parties an opportunity to really talk through the problem, whether you need to just get it off your chest, air your grievances, or, explain to the other side why you're having the dispute, and really be able to talk it through. Mediation gives that opportunity, and it's not as adversarial as going to court. So it means, chances are you won't be fighting the other side, but you'll be coming to the table to have a discussion. And so if you are in a partnership and you want the partnership to continue, settling your disputes in a manner that's more friendly, more flexible, more informal, really gives the opportunity to be able to continue that relationship and really not have a breakdown because there was some small issue that needed to be resolved.
Yeah, and one of the things that I've seen in litigation, and it's frustrating, is the fact that as the longer it takes to resolve the issue, the more crystallized the parties become in their positions, and it's harder to change. In addition, you'll find that dollar claims tend to get higher and higher and higher as the litigation proceeds. So it really is best, and there's research showing this, that it's really best to address those concerns as soon as they come up, and ADR is a tool for that, while the courtroom is not.
And I think a good segue here, but another thing that you can do in ADR that you absolutely can't do in court is maintain privacy and confidentiality in your disputes. So one of the other reasons that you can keep business relationships working together when you use ADR is that you're not out there in court sort of airing your dirty laundry. I think really colloquial way, but good way to say it. Because in court, everything is a matter of public record. The news can catch wind of something that's going on and publish it to their newspapers. It's going to be, in the public record, in the court records forever. And so anyone who's looking up your company, future partners or companies who are looking to do business with you will be able to see these disputes and read about them. But if you use ADR, all ADR processes are private and often they are confidential. So looking at mediation will often have a confidentiality agreement signed up front with the mediator, so that, everything that's said, in that room never leaves. Also, arbitration is a private process. And depending on the rules that you're using, it can be confidential. So for instance, CPR's rules, under our commercial rules, the matters are confidential with respect to the parties, the neutrals, and the institution. Some other institutional rule sets treat it a little differently, but regardless of the rules that you're proceeding under, parties can also sign a confidentiality agreement. And so essentially that means that the proceeding, it's not going to be out there for the public to read about. So parties can really get to the conflict, resolve the conflict, and then be able to continue without having all of that information out there.
Oh, absolutely, Mia. I think confidentiality and privacy are two of the major reasons for ADR. And let me also add to that. Okay, you don't want to air your dirty laundry in front of competitors. You also don't want to do it in front of regulators. So let's say that Mia is a grower and I own a dispensary and we have a contract that she provides product to me on a regular basis. Okay, let's say that I stop paying her and she sues me. Now, what am I going to do? I'm going to come back and I'm going to attack her. I'm going to claim that, that her product is substandard, that her quality control is bad, that it hasn't met testing requirements, et cetera, et cetera. And that's really not the kind, and whether that allegation is true or not, that's really not the kind of thing you want the regulators to hear. So in ADR, you avoid that. I mean, it's not bulletproof, but what you do is you build up layers of protection, which makes it harder and harder for another party to get access to it. You also can structure your process in a way that you're not leaving tracks. For example, in an arbitration, you could agree that there's not going to be a stenographic record, in which case there's no record for anybody to discover later on. But I do think that confidentiality is a huge plus here.
And, it's not just business relationships. As we've been talking about this, I realize we forgot to mention, but it also protects trade secrets and intellectual property information. So, if you are worried about that being exposed and out in the public, you certainly don't want to be in court where there's going to be a record of, those types of things.
Oh, yeah. And I think, Mia, while we're on that subject, let's talk about IP a little bit. Because of the patchwork of regulation for cannabis, including federal regulation, that you really can't be sure, as I said, that you're going to be able to maintain confidentiality. And this is certainly one way to do it. So, yeah, again, it's a very strong point for ADR.
And then one other benefit, which I had already discussed, but we can bring up again, is finality. So for cases that go to arbitration, and this is really for arbitration and not mediation, but for cases that go to arbitration, once an award is rendered, it's final and binding, which means that, you can't go to court and try to appeal it unless there are really very narrow grounds for appeal to an arbitral award, and they really have to do with, like fraud.
Right.
And bias, and not, just because you want another bite at the apple. Parties can, if they want to, write an appeals provision into the contract, and most ADR providers do have appellate provisions. CPR was the first to come out with them, but now more providers have them as well. So for those parties who maybe are nervous and want to have an appellate procedure, it can be written into their contract, but by default, that's not going to happen. By default, once the award is rendered, that's it. It's final. And so that, again, cuts down on time and cost because you don't have to go through an appeals process. You don't have to, worry about all of that additional time. And something that is actually very interesting, but looking, at data and looking at the timelines that are set in our appeals procedures and other appeal procedures, going through an arbitration and an appellate arbitration process can still be faster than going to court without even going through appeal. So the process is still a lot shorter, even if you decide to include an arbitral appellate procedure in there. You'll still be done probably before you would have gotten your judgment in court, and certainly before you would have gotten through the appeals process in court.
Although I tell you quite honestly, Mia, I advise people to not go to appeal. I advise them in their because otherwise it starts to look more and more like a trial to the court.
And I can add to that and say most people do not include appellate provisions. From my experience at multiple institutions, I can tell you that it is just not commonly used. I've seen very few cases where it has been written into contracts, and even then it hasn't been utilized because parties just generally don't want to, further draw out a process that's really already been completed.
Yeah, and I wanted to step back just for a minute and complete a thought about the value of arbitration and mediation when it comes to cannabis IP. And IP, cannabis IP is one of those things that's sort of up in the air about, is there federal protection or not? And generally speaking, no, when it comes to patent and trademark. So how do you protect your IP? Well, one of the ways you can do that is in your partnership agreement itself, where you establish who owns the IP, at least between the partners and investors. So you're providing a measure of protection to your IP.
So I do want to get to the last point of the benefits of arbitration, which I think everyone is here to listen to because it was so prominently featured in the program description. But arbitration and mediation provide a fair and neutral forum. It keeps disputes out of federal courts. Federal courts might be reluctant to enforce cannabis-related contracts. And if you have a contract that you entered into with another party, and you have a dispute and you take it to court and it ends up in federal court, the court might just throw it out. And that, it's really tough as a business not knowing if your contract is enforceable. I mean, I think that's why businesses enter into contracts. They expect them to be an enforceable tool that they can use to, regulate their agreement. And instead, here we're seeing instances where, federal courts just won't enforce the contracts. And it's even happened very recently. The most recent one I can think of comes out of Colorado, which is a very cannabis friendly state. But just in January, there was a case that was in court. It went to federal court, and the federal court just, they said that this is illegal, and so we can't enforce the contract. And so the dispute never got resolved. I think as business people, that's really frightening to companies, especially to new companies that are just forming and trying to make sure that, they're going to be able to keep working and being in business down the road.
Oh, yeah. And that's also something that needs to go into your contract, and that is choice of law. So let's say we have an arbitration, okay, and I win in the dispute with Mia. I can turn that arbitration award into a judgment, an enforceable judgment, by going to the right court to do it. But I'm going to pick the right court, one that has a history of being cannabis friendly. So, for example, I may decide as choice of law, I'm going to pick Colorado state courts, where I think I'm going to have a better chance of being able to enforce the contract. But this is part of the problem with cannabis law, is that you're dealing with a patchwork of jurisdictions, and they may all have different approaches, different views to the subject matter.
That's right. I think these days, more and more state level courts are going to be friendly to cannabis disputes. There are, I think, only 3 states left in the US that have no type of cannabis legality. So as more and more states adopt laws and regulations that are, pro cannabis, they'll be more likely to be friendly state courts, as long as you're not ending up in federal court. And so being in arbitration is very important to be able to, craft that process and make sure you have your choice of law selected, so that you're saying, I specifically want this state to be the state that will be enforcing the contract.
I think we have a couple of questions here. Should we go ahead and address them?
Sounds good. So I'm seeing a question in our Q&A. Where does binding versus non-binding arbitration fit in the process? And why would the use of one over the other be preferable? I think non-binding arbitration is just another one of those ADR procedures that you can use. In that instance, the final and binding that I was talking about as a benefit doesn't exist. It's essentially a process where a neutral will be able to give a determination, but the parties don't have to abide by it.
I'm sorry. I was going to say, though, I probably didn't mean to interrupt you. I view non-binding arbitration as kind of useless.
And so, I think if you're looking for all of the benefits of arbitration and you're looking for a decision maker to bring down an award that the parties can then rely on, you really do want binding arbitration. I think non-binding arbitration is really just a process that parties can use to sort of see where a decision may lie, but because there's really no enforceability there, it's a process that's maybe not used as often. And you wouldn't want to use it if you would want to have an outcome at the end of your matter that can be enforced.
Right. Now, I see we have another question too, and that is, are there lawyers that specialize, and we want to get back to the contract portion of this for sure, Mia, but we might as well answer these now. Are there lawyers that specialize in representing companies in mediation or arbitration? And the answer is yes, there are. And that's something that you should inquire about when you hire a lawyer to represent you, because you don't want somebody who has just done traditional litigation all their life. They want somebody who understands the process. And as me and I have talked in preparation, I mean, we know numerous lawyers and judges who don't understand arbitration. So as the potential client, ask for their level of experience.
Yeah, and I see the second half of the question says, what should I look for when considering hiring a lawyer for this? And that was the answer. Look for someone who has experience. If you're interviewing them, ask about their experience with ADR. Often it's also listed on websites, things like that, but look for experience, because lawyers who don't understand the ADR process will probably need more time to learn about it, or may treat it as if it's a trial. And in that case, you lose some of these benefits, especially, looking at speed and cost and things like that.
And I see we have one more question here. And that you mentioned partnership issues. What other types of agreements, contracts can be resolved by ADR? For example, a vendor, I've had vendor disputes in the past, which came to ADR. Also, investor disputes can be an issue. And I'm going to offer one little anecdote about the public impact when it comes to litigation and cannabis. I recently did a mediation which involved a potential IPO that went bad because a former partner's lawyer wrote a threatening letter to the party, which, if it had become public, would have killed the IPO. And in fact, it did kill the IPO. So that's another reason why the confidentiality is important. But there's a variety of different potential disputes that could be resolved. But again, it's going to be business relationships, and so Mia's going to talk a little bit here about how to include an ADR paragraph in your operating agreement.
Yeah, and just to add on, before I move on to that, just to add on, but really, any type of dispute, any type of business dispute that you can think of can go to ADR. And so, even if it's a construction issue, a real estate issue, a partnership, employment, lots of different types of business disputes end up in ADR. And so, sometimes when selecting your neutral, it may be that you do want them to have more experience in that section. So if it's like an employment dispute, maybe what you really want is an arbitrator who is very experienced, or a mediator in employment law, primarily. But maybe you also want them to have some experience in cannabis as well, because there are certain employment issues there that might be specific to the industry. So you can certainly, have all sorts of different types of business disputes, and look for neutrals then who have experience in those as well.
I see we have one more question here, Mia. I wonder if you want to take that.
You mentioned being a small, medium enterprise as essential for an ADR professional. Wouldn't being a contract and or regulatory expertise enough without product expertise? Wouldn't the parties outline that concern for you?
I say the answer is probably yes. You want somebody who has legal experience in dealing with business issues. They wouldn't necessarily have to have product expertise, though, to do it, although it would help.
Yeah, and again, this is the parties' process. So if you don't think you need something in the neutral's expertise, you don't have to ask for it. When the parties already have the dispute pending and they're looking to select their neutrals, at that point. And of course, just to take a step back, but when parties do have a dispute, assuming that you're using an ADR provider such as CPR, the parties will come to CPR with their dispute, and then CPR will help them get the neutral appointed. And so at that time, parties can really talk to us about who they're looking for as a neutral, and what kind of expertise they want. So it is up to the parties to outline those wishes and those needs to the institution so that we can help you appoint the arbitrator best suited to the dispute. And it can really be whoever the parties want it to be.
And Mia, let's not get away from the contract issue here. I think that's very important.
Yeah, so getting to the contract itself, but to get to ADR, as we mentioned so many times, it's a creature of contract. So that means that the ADR process, excuse me, whether it's going to arbitration, mediation, or any other process that takes it out of court, it needs to be in your contract. So when drafting a contract, whether it's, a partnership agreement, employment, real estate, like any contract that you're drafting for your business, you want to have a dispute provision, and you'll want to have alternative dispute resolution in that provision.
And Mia, now CPR does have some model provisions, don't they?
We do. So one thing that we actually really suggest parties do is not try to create an ADR provision from scratch, and also just not copy paste it from, some other contract you saw it in, but be able to craft their own. And to help parties do that, CPR does have model clauses that parties can use as a starting point, where the options are all laid out. So you just have to decide one or three arbitrators, whether you have a method of selection that you prefer, choice of law. And so it does, the model provisions do really walk you through what you need to include in your contract in that ADR clause. Something else that we do recommend is including mediation and arbitration. So parties have choice there as well, whether they want to do mediation first and then arbitration, whether they want to run them in parallel. We also have something called the CPR's concurrent mediation arbitration process. And so that's, a process in which parties do mediate and arbitrate at the same time. And so a resolution can be reached sort of using the two processes together. So there really are multiple things that you can consider when crafting your ADR clause. And I think that's why it's so important to maybe use a model clause as a starting off point and then customize it to make it your own. And you really do want to customize each one based on the relationship and based on the contract, and not just copy paste something that, you saw somewhere else.
Right. And also, you can be creative with this. You could call for both mediation and arbitration. I mean, a typical clause would be one that where the parties agree that from a date of notice, mediation will occur in 1 month's time. If the mediation is unsuccessful, then the dispute will go to arbitration. And I would want to add too, when it comes to when it comes to contract clauses. Yes, you want a good ADR clause, but given the nature of this business, you may also want a receivership clause, and that is, where the parties agree that if they are in major disagreement about some aspect of the business, that the court will be able to appoint a receiver to run the business while they're working through the dispute. And you'd be surprised how often that's useful. Also, I think that in your contract, you want to make sure you have a very sound dissolution paragraph about what happens if you decide to split up. And finally, as we mentioned earlier, in your contract, you can determine who holds the IP rights. So the contract can be a very creative device for you. And if you think ahead, can save you a great deal of grief. I see we have a comment from Yvette.
And just before we get to Yvette's comment, I did want to add one other thing. But it often happens that, maybe you didn't think that you wanted to utilize arbitration, or you didn't know about it when you entered into your contract, but you came to this presentation or otherwise learned about the benefits of ADR and realized that you have a contract, you now have a dispute, and the parties both agree that going to court is not a good idea. Parties can also submit their disputes to arbitration or mediation, even if it's not in their contract, referred colloquially as submission agreements. It's essentially just an agreement parties enter into after the dispute, saying, we agree to go to arbitration, we agree to mediate. It essentially would include all of the same things as the ADR clause would in the original contract. It just happens after the dispute arises. And it's another way to get disputes into alternative dispute resolution and out of the courts. And I believe that my colleague, who's been posting some helpful links, has given links for both the model clauses that you can use, but also a link to a page that just walks parties through how to file a submission agreement.
Right. Although let me add to that it's a lot easier to get the parties to agree to an ADR clause when everybody is still getting along and happy, as opposed to when the dispute actually arises. But Mia's right. You can agree at any point that you want to go to ADR.
Okay, so turning to the question from Yvette, many of the disputes occur over the locality's ordinance language and lack of understanding by parties engaged in forming a relationship. Before documents are signed, I've found that using ADR tactics can save a lot of grief and threats of lawsuits. Your thoughts on this? What do you think, Bob?
Yeah, and I guess what I'm having a little trouble understanding is the ordinance question. And kind of what kind of factual situation that would arise. Localities ordinance language.
I wonder if we can get a quick addition on that.
Yvette, can you help us on that?
Yeah, you've been great adding some flavor to your other questions, Yvette. So feel free to either post a follow-up question to give some clarification there, or post in the chat room to potentially give Robert and Mia a little bit of a better understanding of the perspective you're trying to get on that question. Oh, there we go. So looks like she's
okay. Yeah. Now, in which case would your adversary be the city itself? In other words, would you be having an ADR proceeding between the parties to the contract and the city? And that is possible to do. And by the way, just so you know, Yvette informed me she's a former prosecutor, so she's done this. All right. It is difficult sometimes to do ADR involving a governmental agency, because oftentimes the individual lawyer's power to settle is greatly limited, may have to go back to another governing body. So it's tougher. It's tougher than it is between private parties, because governmental units have their own hierarchy and their own regulations about how they're going to resolve disputes.
And I think also, if I'm reading this question correctly, but the regulations. It says here parties don't understand regulations. But it can be sometimes that parties entering into an agreement or a partnership don't understand the regulations that they'll have to be following when they enter into it. And so having, mediation as, a step in the contract, if some dispute arises because they're unable to perform because they didn't really understand these understandably constantly changing regulations, it can be an opportunity for the parties to really work out a solution and continue working together, rather than having, going to court and like ruining the relationship.
Yeah, and I think Yvette has clarified what she's getting at. The cities are reluctant to get involved in making a determination as to who is correct in their interpretation of an ordinance. That's exactly right. That's one of the difficulties of dealing with governmental units.
Great. So I see that we only have 5 minutes left, and I do want to make sure that we can answer any other questions that are out there. So if you have any questions that you've been sitting on, feel free to throw them into the question and answer, so we can address them before the end of the program.
I was going to say, Mia, pardon me. And also, if you want to read more about this, I have an article on my LinkedIn page that discusses what we've been talking about today. So please feel free to help yourself.
Yeah, and I think, education is really important when it comes to these things. Learning more about ADR processes, learning about, some of the questions we've had, how to select a lawyer, how to select your neutral, things like that. There is a wealth of resources out there, on the internet, on our LinkedIn pages. CPR is working on putting up a website page with more resources. So maybe Bob, we can even link to your article on there so parties have it as a resource. But it's certainly really important to educate yourselves on this, the same way as, educating yourself when you're going to court as to what all of the laws are, what the court's procedures are. You want to have that same background information ready if you're going to go to arbitration or mediation, to understand the process, to understand the rules you're using, to understand, all of the options that are available to you. So certainly we're not able to cover every answer or, ask every question in this 1 hour. So continuing to educate yourself and learn more about ADR and the processes is very important.
Right. And let me just add to that. I think one of the questions they may have is, can you help us put an ADR clause together? And I think, Mia, the answer is yes, isn't it?
So certainly, we have our model clauses. We're also going to have, we're working on revamping a tool that we have for, parties who can just go onto our website and like walk through step by step to create their own ADR clause. Parties can also come to CPR as a resource and ask us any questions about their clauses, to, take a look and see and just figure out what they're doing. And if they have any just ADR related questions, we are a resource.
A very good resource.
Fantastic.
Yes, I've been a member of ADR for more than 25 years, or CPR for more than 25 years, which is probably longer than you've been alive, man.
I will take that as a great compliment.
Perfect. Well, I don't think that we could have concluded the program on any better note than saying that if you have more questions and if you wanted to actually utilize the amazing services that our panel has done a great job reviewing, to reach out for more information. We know that Lily Schropp and Mia Levy from both CPR have been here in the actual audience pool as well as the panel at posting. Feel free to reach out to either of them directly. Don't hesitate to post your LinkedIn profile here in the chat room for the next few minutes so everybody can follow those links, make those connections while we're still here in the room chatting about the program. And with that, actually, do you either want to leave a final thought for anyone else in the program besides what we closed out with already?
In terms of final thoughts, I'll let Bob go second and I will go first. I just do want to say, the benefits of the arbitration process, mediation as well, but I'm thinking specifically arbitration right now, are so well suited to the cannabis industry. They're great for other industries as well. And of course, I do like to promote ADR as useful for business relationships. But looking specifically at the cannabis industry, these benefits are amplified. And so I think it's really something that everyone in the industry should think about using, should think about keeping their contracts out of court and using, this process that is just so much better suited to the disputes.
Absolutely. Absolutely. It's all good. It really is.
Fantastic. Well, with that, I think we'll close out today's program with our typical end of event member appreciation credit sequence. We'll stick around for the next few minutes while we are getting that revved up, though. So feel free to post any questions that you might have remaining for the panel, as Mia instructed, inside the chat room or on the Q&A board. We'll make sure to take any open questions that might come in over the next few minutes and use those as the starting off point for a post-broadcast conversation inside of NCIA Connect, the NCIA members only community platform, as well as on NCIA's YouTube channel. So if you are trying to share today's amazing presentation with any of your colleagues, coworkers, or anybody at the industry at large that needs to know more about the ADR process in general, as well as CPR Institute specific products and services, do direct them to the Facebook Live. That will be archived immediately and available to reshare. Oh, awesome. Thanks for putting that LinkedIn profile in there, Justin. Follow their lead and get those LinkedIn connections made while we're still here in the virtual meeting room. And beyond that, do look out for a follow-up blog post to be posted to NCIA's website, as well as our YouTube channel first thing early next week. And then it sounds like the CPR team is also going to have a landing page created with some resources that might be useful and beneficial. So stay on the lookout for a final post-broadcast email to be sent out to all of you all. That'll include our appreciation, links to all of those landing pages, and any additional resources that might be useful to make the most out of your participation in today's program. Follow along with everybody over the next few minutes. Post those thank you and appreciations in the chat room. With that, thank you all so much for participating in another NCIA Industry Essentials educational webinar. Feels really great to have beaten the heat today while engaging with our network in a live format. So we really sincerely hope that you'll continue your participation with all of these interactive educational experiences into the rest of the year. You can head to the events section of NCIA's website following today's broadcast to secure your spot in all of our upcoming virtual and in-person events. On the in-person front, for any of you all based in the Colorado market, we do have some in-person events taking place in Denver in late July. And for any of you all that are hoping to make an impact in Washington, D.C., along with all of our other members and supporters, please do head to the NCIA website to learn more about the return of our 10th annual Cannabis Industry Lobby Days. That is only open for NCIA member businesses, but will be taking place across 2 days from September 13th through the 14th. Huge thank you once again to the CPR dispute resolution team for spearheading today's program. We really appreciated you all highlighting this unique process and really talking to our members and supporters about how it can be specifically applied to the cannabis industry. As an association that made our name sort of on the nuance of the Section 280E sort of concern with the industry, we definitely understand the nuances that go into some of these legal processes. So we really appreciate you all spreading the word about the ADR process to our network. With that, we'll leave you all with this end of event credit sequence, highlighting the 25 plus member businesses that did participate in this afternoon's program. If you don't see your member company listed here, don't be discouraged. That just means that you need to head to our website, thecannabisindustry.org/join, following today's session to join the movement for a responsible and equitable cannabis industry. Thanks to you again to all of our audience members for engaging in the Q&A process. Enjoy, and we hope to see you again for another NCIA Industry Essential educational webinar later this month. Thank you. Have a great one.
Okay.